Well, today's the day. The two men involved in the Manchester airport incident finally appear in court, the Magistrates' Court, and they've been sent to the Crown Court, so I'll explain a little bit about what's going on in this video. I'm not going to comment on the specific case itself for obvious reasons, but there's a few questions people have raised in the comment sections and over on X, so I'll deal with some of those. We also have Mike Amesbury, Labour MP, who was filmed punching somebody, and he was brought to court. We'll talk about him as well. But also some rather embarrassing exchanges in the media and in Parliament, because an MP has been accused of being embarrassed in Parliament for asking a question to which the answer she felt was wrong, but in fact the news reporting on that was wrong for reasons I'll come to in this video. That was to do with migrants getting priority support in the NHS, so I will deal with that as well. But first of all, if you're new to me on this glorious sunny but somewhat cold day, I'm Daniel Shensmith, a barrister of England and Wales. I'd be really grateful if you hit that subscribe button. We're soaring towards 1 million subscribers now, thanks to you, the general public, and as Elon Musk says, you are the media. Speaking about me and you, of course, so I need your support, so please do subscribe. I'd be really grateful. So let's take a look. First of all, the story of the hour, story of the day. These two men from the Manchester airport incident finally appear in court. All credit to Manchester Evening News here. I will link this in the description below. Please do make sure you go and read that article and give them your support in full. Go and follow them on X and so on. Now, just as a recap, and regardless of what you saw on social media, the alleged, and I'll come back to why it's alleged in just a moment, the alleged altercation involving police officers between Mohammed Amaz and Mohammed Ahmad and the police officers. Mohammed Amaz was charged with 2 counts of ABH, actual bodily harm, and 1 count of assaulting an emergency worker, the police officer, and 1 common assault. Mohammed Ahmad was charged with 1 count of causing actual bodily harm, so a section 47 ABH. And so let's run through. So actually in reverse order, the case was adjourned, but let's skip down to their reporting on the beginning here. They were there to bring updates as and when things happen, but I'd like to give a little bit more information on this video in conjunction with their reporting on this story. So huge gratitude and credit to them, but I'll give you a bit more information here. Now, the first thing that struck me is, well, let's just go right back to the beginning. So this case did and was always going to start life in the Magistrates' Court. All criminal cases start life at the Magistrates' Court, even if it's the big M word offence and it goes to the Crown Court and will only go to the Crown Court, it's indictable only, it will still start life at the Magistrates' Court. So those of you that might be interested in learning law, and I know many of you have written to me, I humbly say that many of you have written to me that you've embarked on law degrees and bar course and all sorts of stuff, you aspiring barristers, some of you, because of my videos here. I am humbled and I'm grateful for you watching and supporting, and so these might inspire some of you to learn it as well. All criminal cases will start life at the Magistrates' Court. Why? Well, it's just where it starts. So there's a lot of housekeeping things. There are some pre-appearance things, pre-trial things, and lots of preparatory stuff that we wouldn't waste the time of the Crown Court with until it gets there, and obviously if it gets there. So the first thing to note about this is not only that did it start life at the Magistrates' Court, but it also had a district judge, which is a full-time judge. He was appointed, I think, early 2023, sitting in the Northwest Circuit. And we don't always have a district judge at the Magistrates' Court. You might have a single or a panel of lay magistrates. But in this case, I think because of the media attention that this case had, to ensure that everything ran properly, to control the media that would obviously be present, to control the proceedings and everything else, to make sure it went smoothly, even though it was short and sweet this morning, for reasons you'll find out, we had the presiding judge of a District Judge Hatton to oversee the hearing. That's the first thing. Then, of course, the case was called on. Now, first of all, very often cases are listed at 10 o'clock and they could be called on any time, but obviously this was called on right first thing in the morning. They didn't want to keep people waiting, so they brought this case on at the outset. This obviously garnered a lot of media attention and therefore they wanted to bring it in court at the first opportunity, first thing in the morning. So they were brought into court. They were both wearing suits. The charges were read out. Now there's an important bit here. Neither defendant made an indication of plea, and that warrants a little bit of explanation. Now the judge also addressed this point, addressed the defendants and ensured that they've made no indication as to plea, and sent the case to the Crown Court. Now Let's deal first of all with the no indication as to plea. Now, of course, this is a general explanation as to how this works rather than commentary on this case specifically, and the sun goes in, so I'll change the ISO settings on the camera. But when they make no indication as to plea, then it affects credit. If ultimately they are found or plead guilty, it affects the credit that they get off the sentence. So allow me to just explain how that works. Even if a case is only ever going to the Crown Court, let's say it was indictable only. I mean, these offences were either way. They could be heard at the Magistrates Court, they could be heard at the Crown Court. But let's say it was an indictable only offence and it was going to the Crown Court. There is always an indication of pleas, literally on the form, whether or not you are likely to plead guilty or not guilty. And there's even been cases that have gone to the Court of Appeal because it was written in rather than literally the box checked and so on. So there's an indication whether you're likely to plead guilty or not guilty, even if there is no formal plea at that stage. And that's important because the earliest opportunity to indicate your plea might affect credit. Credit is the amount of time that comes off your sentence for indicating that you are likely to plead guilty at the earliest opportunity. Now, the first formal plea could be taken at the Magistrates Court, or it could be left until the Crown Court. Now, in this case, the case has been sent to the Crown Court, because the reporting here doesn't say that they have entered formal pleas, guilty or not guilty. They've just not made any indication as to plea whatsoever. Just as an aside for a moment, as you can probably imagine, I get lots of companies offering to sponsor the channel, and I turn most of them down. For example, recently I had a wine company and a beer company offer me lots of money to promote their products, but because I don't drink anymore, I just didn't feel that was right to promote them to you. But one company I am pleased to present to you is a company called Sihu, who produce ergonomic chairs. Now, as a professional that spends a lot of time sitting down at a desk, and if you are someone that spends a lot of time at a desk, you will know the benefit of a comfortable chair. And particularly as I had a spinal injury many years ago that continues to present me with pain to this day, a comfortable chair is an absolute must. So they sent me their Duro S100 chair, which is futuristic in design, very dynamic, made from what appears to be a material which is a long-lasting woven fabric. It's available in black and white, and of course it's got adjustments for height, a reclining feature tilting back up to 135 degrees, but that's not the most important thing about this chair. The most important thing for me about this chair is that it is dynamic. It allows you to move freely and encourages you to move and prevents you from sitting in one place, which, as someone with a spinal injury from many years ago, I can tell you sitting in one place for far too long is the absolute key to back pain. Now, as you can imagine, over the years, I've spent thousands on different chairs. I even paid for a Kickstarter project, hoping that that would solve my problem, but that just broke after a few weeks of using it. But this chair is absolutely going to fit the bill because it allows me to move, it prevents me from sitting still, and it's just a comfortable chair. And most importantly, having used it for many hours now, as you've probably seen from recent videos, I don't have the back pain sitting in this chair like I do in my other chairs in my other office, which you've seen in my other videos. So if you're looking for a decent chair or you want to gift a decent chair to somebody else, this is an affordable yet really good option for you to buy. And of course, you get a discount on my channel. There's a 6% discount link in the description below. So go grab yourself a really comfortable chair, and thank you to Sihu for sponsoring today's video. Now, the maximum available credit at this first opportunity to indicate a plea is 1/3 of any eventual sentence if they were found guilty or pleaded guilty. And that first opportunity to indicate a plea is the first stage of the proceedings, which is generally taken to be the first appearance, the first time they're in court, the first time they have that opportunity to indicate whether or not they will plead guilty to the offence, or offences, as the case might be. Now, after that, that 1/3 will reduce to 1/4, and then on a diminishing sliding scale will reduce to 1/10 at up to the start of trial, and then it will disappear. And it's always down to the discretion of the judge on sentence, etc. But as you can see here, as the judge has said to them that they've made no indication as to plea, the judge has said that he's going to send the case to Liverpool Crown Court. Now, I presume in this case, because there's no mention here that they've elected Crown Court trial or anything like that, ordinarily if you are charged with an either way offence, you can elect a Crown Court trial, so you have a jury. But in this case, there's no mention of them electing Crown Court trial. It just says that the judge has said that he will send the case to the Crown Court. that is being sent forthwith to the Crown Court, so there was no formal plea entered and no indication of plea at this stage. At least this is what the reporting is saying. And what that would mean is, if there's no indication of plea, and obviously they've not entered a plea, that they would lose that full credit that they would otherwise get if eventually they were found guilty or pleaded guilty at the Crown Court. Then it says that they've been bailed to reappear at Liverpool Crown Court on February the 13th. That brought the hearing to a close. So as I said, within 20 minutes, it was all done. Much of that will be confirming paperwork and details and all of those kind of things. And then they walked out of court. Now, many people in the threads have asked the very reasonable question, why is it alleged when there's a video showing what they are supposed to have done? Well, the reason that it's alleged is because of two reasons, really. First of all, in any criminal case, it is always the burden of the prosecutor to prove the case on behalf of the Crown against any accused individual. Regardless of how strong the evidence is, it always must be proven to the criminal standard, which is beyond a reasonable doubt, or to adopt the new term, so that the jury is sure that they are guilty of this offence. The second reason is, regardless of how clear-cut something might be, let's take a hypothetical example. You see a video of somebody taking a car that doesn't belong to them. There's no dispute that it doesn't belong to them, and they take that away. If they're accused of taking a vehicle without consent, you might think from the video it's absolutely plain as day that they've stolen the car, taken it without consent. However, if you put in any kind of number of different defences, for example, it was someone collecting it for the garage, part of a subscription service to service the car that they weren't aware still existed, or it was someone who'd taken it by mistake, or it was a friend who believed, they had a chat in the pub the previous night that he's forgotten about, that he could borrow the car, etc., etc., etc. Lots of different reasons that could be the case. That is an alleged offence, because any possible defence must be brought to court and either proven or disproven. And then if it's raised a defence, the prosecutor must then disprove the defence to the criminal standard. So in a case like this one, now I'm not, I stress, commenting on this particular case for the Manchester Airport incident, but in a case like this one, if somebody were to assert, let's say, that their actions were mistaken or self-defense or any one of these kind of things, it will be down to them to raise any such defense. They have an evidential burden to raise this sort of defense, and then the burden shifts back to the prosecutor to disprove any of those defenses and thus seek to prove the offence against the individuals. That is why it's alleged, and there's another fundamental reason overall and an overarching reason that they are alleged offences, and that's because we must have a fair system. In order for an offence to be prosecuted and defended fairly, it must be on an equal playing field with a prosecutor and a defence fighting the case just as fiercely and just as fairly, and it must always be proven by the prosecutor. As it happens, a defendant need not have representation, they need not give evidence, they're not compelled to do so, but obviously there would be an adverse inference drawn if they refused or failed to give evidence, or indeed if they gave an inconsistent account or any of those kind of things. But in the interests of a fair justice system, that's why it's alleged, and it must always be proven in court to the same criminal standard. Right, back to court, and we have Mike Amesbury, who was in the Labour Party. You'll recall this video here. I'll mute it and play it. You'll recall this video here circulated on social media, and he appeared in court today on charges of assaulting one of his own constituents. Well, this was a relatively short and sweet. I will link this Guido Fawkes article in the description below as well. He's now been expelled from the Labour Party, having been suspended, as he pleads guilty to assault by beating. And that's really the extent of the update for this one until we hear about sentencing. But now to something which may appear rather embarrassing on first blush, but actually warrants a bit more explanation. So if you were to take the word of this article here, Tory MP embarrasses herself with false claim about preferential access to NHS services by illegal migrants, you might conclude that Sarah Ball here has embarrassed herself by asking a question with a false claim about preferential treatment. So have a listen to the question and answer yourself, and then I'll explain why that article was wrong.
Does the Secretary of State believe it is fair that undocumented illegal migrants get priority access to the NHS over British taxpayers?
Mr. Speaker, they don't.
So very short and blunt response. So Sarah Ball, if you didn't quite catch it, asks, Does the Secretary of State believe it is fair that undocumented illegal migrants get priority access to the NHS over British taxpayers? And in response to that, Angela Eagle responded, "Mr. Speaker, they don't." And so hence the headline here saying that Sarah Ball has embarrassed herself. On the contrary, I think this headline is embarrassing because the headline is wrong. Let me explain why. You may remember a video that I did some time ago talking about the 987 Inclusion Health Programme from the NHS, which said that certain people within groups may be more vulnerable, such as homeless, drug addicts, and of course illegal migrants or asylum seekers or even failed asylum seekers, maybe within this group. Now, if they are on that group and they're on that list and they're referred and whatever and however it works, this 987 Inclusion Health, which was a part of North Central London, and there's various other similar schemes in other trusts, this said that they'll usually be seen within 15 minutes. They'll do routine blood tests and simple assessments, and then they might get a further, more robust examination, and then treatment and admission if necessary. And of course, that presumably is what Sarah Ball was referring to. Now, this may have been in the media without my video, or maybe they saw it from my video, I don't really know. But since then, I also posted on X to say that the NHS for North Central London has removed this page from their website. So either that was an out-of-date page and it was wrong, or they've changed their mind about offering the scheme because it's come under scrutiny, or they still offer the scheme but they've just decided to remove it because they don't want anyone to see it. Not really sure which, and I haven't had a response. Not that I can see anyway. I haven't scanned every single response down here. But it has given rise to criticism of Angela Eagle's responses here because she said, "Mr. Speaker, they don't." Well, clearly they do, because in certain areas there are preferential treatment schemes set up where people within vulnerable groups do get seen within 15 minutes. This was my original video talking about this. When I went through in great detail and looked at the website, and you can see here actually if I move it around a bit and zoom in a bit, you can probably see a little bit more. It says here people of certain groups. Vulnerable migrants make up part of this group who have reported limited access to translation services, which generally impacts their capacity and confidence to engage with care and support, and various other people in those groups as well. And so they are most certainly on this page within those groups. So whether that exists still or not is another matter. But certainly that page did exist until it was removed. And it did say that they get preferential treatment. So actually, I think that original headline is rather embarrassing, not a question by Sarah Ball here. And finally, just a reminder, I haven't forgotten about it, but there's no update that I can see so far. Former Labour MP Ivor Kaplan was arrested. This was reported by Spectator a few days ago, was arrested then on suspicion of child sex offences after a sting by paedophile hunters. Footage of Kaplan in handcuffs was live streamed on Facebook, lasted 30 minutes, attracting more than 36,000 views, etc. Sussex Police said in a statement, "We are aware of footage circling on social media showing a man in Brighton being detained on suspicion of engaging in online sexual communications with a child. Officers can confirm that a local 66-year-old man was arrested on Saturday and currently remains in custody." And so if you want the full article, pop over to Spectator, do support them, as they say here, £1 a month. Not sponsored by the Spectator, of course, just supporting the media as it's reporting here. So I hope you found those useful and somewhat informative updates. Please do remember to like the video and subscribe. And as always, thank you for watching.